Okay, good evening and welcome to our Thursday online seminar. Tonight we are joined by Mohammed Haque, who is consultant barrister, adjudicator, and a quantum expert. And this is the latest in his Adjudication Matters series. Tonight he's going to be talking to us about jurisdictional challenges in adjudication. As always, Mo is happy to answer any questions you might have, but if you could use the chat facility or the Q&A facility in the toolbar at the bottom to pose those questions for him, and he will happily deal with those at the end. And as always, if there's something you'd like to ask him, but you don't really want to ask it in an open forum, you can see on the screen there his email address, mohammedhaque@silverllp.com. He will always happily discuss these offline with you if you've got a specific issue that needs some advice. Okay, Mohammed, over to you. Take it away, please.
Thanks, Julie, and welcome our usual participants. If you are new to this, I've been doing a series and I'll be doing up to the end of the year. That's about the adjudication matters, meaning trying to shape up adjudication from front to the end, up to challenges, and then having two sessions towards the end of the year about making a payment adjudication claim and defending, as well as making a time or money claim in adjudication and defending. I will not be going to other breaches of contract and so on and so forth because it becomes complex. But I have touched upon these aspects of jurisdictional challenge in the past as well. However, I always felt that there has to be one full session for it. And when I started compiling the slides, I realized that I won't be able to cover everything. So I will be limiting myself in and around threshold issues, including natural justice. I will not be considering the issues of internal jurisdiction because that's a different chapter, and I won't be doing justice if I try to cover too much within this short period of time. So why I'm so late in discussing jurisdictional challenge, those of you who are familiar with adjudication in England and Wales would know that it comes quite early, even before the response come through. There is normally a jurisdictional challenge. Towards the end, you'll realize why, because jurisdictional challenge is something which starts actually even before the parties start making their submissions. And I will explain how, and then it continues right up to the end. And sometimes, unfortunately, for the adjudicators, sometimes if that's found after the adjudication event, certain aspects, that disaster is something that no one can save it from. So that's the reason I discussed the whole process, the left jurisdiction, although it's raised quite early. Now, what is jurisdictional challenge? That's the first thing, because I love to describe the concept at the beginning of any of my discussions. And for my own knowledge as well, I just like to set the context first. And that's what is it? What is it? Well, you must know that we are talking about construction adjudication under the Act and the scheme. So it's the creation of statute, and it's an ADR tribunal. It's added to the contract under the implied term, which is overriding, if certain conditions are fulfilled. Now, every tribunal has a limit, and that's called jurisdiction. So a tribunal may have a territorial limit, like the adjudications in the UK are for the England and Wales, and then there is a scheme for the Scotland and other Northern Ireland separately. But territorially speaking, the adjudication in England and Wales requires that the site regarding which, not the parties, the site regarding which the adjudication is, the parties are referring to an adjudication must be within England and Wales. So that's kind of a territorial limit. This is jurisdiction. So any kind of limit defining or mapping the borders lines of, or the borders of the four corners of the adjudicators' rights, duties, powers to exercise is a jurisdictional issue. Now, if one of the parties, or even the adjudicator himself, I will again later on explain why sometimes it's rare, but sometimes adjudicators have a duty even to raise their jurisdictional issues and say that this is a challenge to my jurisdiction, and I'm sorry, I do not want to proceed unless such and such thing happens, and I say goodbye. Okay, so that's not, in vast majority of cases it's made by the responding parties, but that's not the only thing. The referring party could make it, and so does the adjudicator occasionally, though, but it's a possibility. So who makes it? Any of the parties would make a jurisdictional challenge. However, having said that, in vast majority of cases, the responding parties raise it, and as soon as the referral is served, which completes the appointment of the adjudicator, mind you, nomination is not the completion of the appointment. The appointment is completed on the day the adjudicator receives the referral. So that's the time when his jurisdiction starts under the Act of the scheme. The appointment is complete as soon as he notified the parties that he has received the referral. And as soon as that happens, the responding party, the first thing they do is trying to find out, is the adjudicator crossing the limits of its jurisdiction? And if they think that that is the case, what they do is they send challenge to the jurisdiction of the adjudicator. So when to make it? As soon as possible, as soon as possible. And as soon as possible doesn't always mean that at the beginning. It could be there are issues which you can raise quite late, if that's found later. They say even after the adjudication, if something, there are issues of natural justice which is found later on, that can be raised. And I'll give you an example, a sad example, of course, but that's the reality. So having said that, the expectation is that as soon as you find it, you raise it, okay? And the practice normally is for the responding party to pick it up right at the outset and raising it up that, look, there, you do not have the jurisdiction to proceed, so please say goodbye. Now, the second vital question, which is, if you are a party representative, or I didn't know earlier that some of the adjudicators even of types of LVD and others attend my this webinars. I've come to know because one of them have informed that he attends, and we had a chat the other day. So if you are a party representative, especially to remind you that there should be a purpose of making the challenge. It's just not there. Because sometimes what happens, people take it for granted that it's very fashionable to make an adjudication jurisdictional challenge, so I will do that. And in your early days, it's quite common as a party representative to just raise one. But I would suggest, I as a party rep, I still occasionally represent parties, very occasionally, but I still do, if that's complex enough and the parties feel that I should work. But throughout my period as a party representative, I only raised a jurisdictional challenge where I knew that it's going to be successful. And this was something like a case law or something which says clear cut. I never ever ventured on kind of a fishing approach that throw it into the kitchen sink, at least I'll get a single extra 1 or 2 days. Why? And sometimes I was bold enough because when I ran a practice of representing parties in adjudication, I had in my team as seniors, I had a senior adjudicator and a QC, and then the other juniors, and I was the partner there. What I used to do is to create every time a representation and then get a quality check from the QC, sometimes from a quantum expert or a QS if that's required. There were many QSs internally, so we never needed to go outside. And then also from a senior adjudicator, that we want to make this jurisdictional challenge what you think. And provided you make your case out very nicely, what happens? The seniors, they do not take a lot of time. So although they're very expensive, but you can get an opinion from a QC or from a senior adjudicator only kind of using an hour's time for its own, and just get back to know what you are thinking, or want to go ahead is not so correct for adjudication, because it's very technical practice, and sometimes you may have certain knowledge of law which is well and good for arguing in front of a court, but it may not have any value in the mind of an adjudicator. So since you are in front of an adjudicator, it's best that you check like that. So if you have a counter check, well, I'm not saying you have to go to a senior all the time. There are wonderful guidance books like the Adjudication Society and the CIRB has jointly published on only a 32-page long book, exactly considers every single point you need to know, about jurisdiction. So you form a view that there is jurisdictional challenge, and then counter check, please, that really would it sustain or not sustain. Don't get excited by reading a case law, which has an obiter kind of comment that there is a jurisdictional issue, and say, I've got one. Please don't. Only do it. That's my suggestion. Only do it if you really have a prospect. Now, interestingly, in my practice as a party rep, I found once, that only happened to me once, that I was the responding party, and the referring party was represented by one of the leading solicitor firms in the country. And the partner construction came back to me and to the adjudicator that we see the point in the responding party's argument. And however, if he's looking for some extra time, we're ready to extend the time to submit the response by another 7 days. So sometimes what happens, these are done just to gain some extra time. Now, sometimes even people who are new again, they think, if I do that, what will the adjudicator think? How would it look in front of the adjudicator? I can tell you one thing. The adjudicator do not care about how an argument looks like. The only thing they're worried about is this a valid point of law under the contract? Is this a valid point of evidence under the contract or the law? And then they apply the point of law to the evidence and just decide. To them, if somebody says, the other side is utterly nonsense, how could he do this? Even their bullies sometimes ask a lot of the adjudicators, but we are trained not to care about it, because we are not in love. And don't forget the fact that if you're a party representative, that it's the duty of the other side's adversarial. So they will try to raise objection as to everything. That's their duty. That's what they have been paid. And they will be, if they don't do it, and then finally it was found that they should have, then there might be a problem. So adjudicators do not take it personally at all, normally. Or of course, there are exceptions, we're all human beings, but normally they don't. They get themselves focused on. And again, my request is, if you really think there's a good prospect of being successful, by all means, go ahead. Because what will happen, the adjudicator will resign, And then you can, again, the referring party can resubmit the dispute, correcting the jurisdictional issue in most cases. And either, if unless the personal involvement issue of the adjudicator is concerned is there, what will happen? The A and B will reappoint the same adjudicator. So all in all you get is like a 7 days time. So by all means, if you are hungry for that, that's fair enough. But if not, then there's no point. Okay, I've already said that I'll not be discussing internal jurisdictional issues today. Just give an example. As I said, a territorial limit. If there is a site in Northern Ireland or in Scotland, and if you are bringing the adjudication under the scheme, or which is applicable to England and Wales, that's a territorial limitation. You cannot do that. Okay, you cannot do that. So it's just like a threshold. Can I set myself on the train? That's Trillian and Devonport. I don't like to refer cases, but just, it's so obvious a name that it came to my mind that, okay, I consider Trillian and Devonport. But normally the question as is asked by the adjudicator themselves, that can I set myself on the track so that I can carry on? That's called threshold. But there are issues sometimes internal, although he has the power to do so. But then as it developed, you see that, no, you can't take this argument on. For example, if the adjudicator himself or another adjudicator earlier by the same parties regarding the same dispute or another dispute made a conclusion, then that's binding on the new one. So that part of the thing, dispute, is no more open. So that's an internal question. That's not a threshold. The adjudicator will still decide the dispute, but will not be able to redo it, certain portion, which is already decided by another one. So that's internal. I'll not discuss it, the internal part at all. I'll be discussing the threshold ones, where the adjudicator considers if he can set himself on the train. Threshold jurisdiction. Now, sometimes the parties, and especially the responding parties, and if they are not familiar with the adjudicator's training, I would suggest that RICS runs a training for its panel members, but it's open to anybody. And I have attended 5 of them when I was not a full-time adjudicator, and I've learned a lot by attending them. So you may, if you want, attend them, even for 2 reasons. You'll have all the senior adjudicators attending them. It's compulsory for us. And so you get your course mates, the truly the big names. Well, if face-to-face happens, you will see like 9 to 10 top range adjudicators and spend the day with them. That's a big opportunity. It was for me to learn from them how they think, how they talk, and how they approach their work. But if you are someone who doesn't have that background, you may think that the adjudicators do not consider the issue of jurisdiction. That's absolutely wrong, because even before the A&B appoints you, the first thing they inquire with you, that do you have any jurisdictional issue? And expressly they ask the adjudicator, is there a conflict of interest? Okay. Do you have the requisite expertise? And again, I will politely and humbly remind you that the adjudicators are in no way seeking work, because by the time you become a full-time adjudicator, and there are so many A&Bs in the country, you are always kind of chased by the A&Bs that, would you take one? Would you take one? So it's by no means that they, just because there is a nomination, they'll jump on it. So the A&B ask jurisdictional questions to the adjudicator before he accepts the invitation to act. And the A&B's run regular trainings for the adjudicators of their panels to teach them how the jurisdictional issues should be kept under constant check and monitor. Okay, it's a duty. It's a duty of the adjudicator. So don't think that, okay, adjudicators are crazy about it. They're just looking for adjudication, so they're not going to say no. I even heard like senior counsel in their presentation saying so, but that's not at all the case. As I said, only when you become an adjudicator or go and attend the courses where the adjudicators are trained, you'll realize that how, why, when the adjudicator starts looking at the jurisdiction. That starts right at the beginning when the invitation comes. As I said, the ANBs ask you straightforward to the adjudicator, is there a conflict of interest? And what do they mean by it? Unless you pass that module in whatever A and B and training is there, you won't be able to continue. It's like a CPD. Every time you in 5 years, for example, RICS recruits in 5 years only once, and it's a compulsory requirement that in your last 5 years you have passed that. You attended the training and you have passed it. So it's very clearly explained to them what a conflict of interest is, and it's requested that keep that on, keep monitoring it. Don't just think, okay, at the time of invitation I was okay, so that's going to be okay. No, that's not going to be the case. I'll come back to this point again towards the end of the session because I'll be discussing natural justice, and I prefer to discuss the both under one head. So the second type, the adjudicator at the beginning monitors, even the monitoring starts from the A and B, because they need to find out if this is a construction contract, because they do not want to spend their time and nominate and then finding that, okay, no, this is not a valid nomination. You know, why would they spend their time for nothing? So this should be common knowledge for every attendee in this discussion, that the adjudication is the creation of the Housing and Construction Regenerations Act and the schemes under it, and the Act in 1045 defines what a construction operation is and a construction contract is. Of course, it has to be an ordinary kind of a task which is understood by the people in the country as construction work. And this includes the professional works as well. So if you're a QS, if you are an architect and structural engineer and providing your services as a consultant, that's also included there, okay? Now, obviously, there are then excluded contracts as well. So, and excluded contracts are of two types. I've mentioned 106, but not 107 of the Act, because excluded contracts at the moment for England and Wales are, of course, the construction contracts where the employer is a private individual who's issued the contract where the employer would reside, okay, as or use the building as their personal residence, okay, for occupy the building as a personal residence, okay. And obviously the question comes sometimes, not very often, but it comes that what is the relevant point of time in establishing whether the employers was entering into the contract to have to use their building as their residence is at the point when the contract was made. So if I mean, it might sound funny, but I experienced it as an adjudicator. There's somebody who never mentioned that this is for our own residence, just went for a contract, and it could be established before me that the idea of moving on to the house actually developed afterwards. So it was a JCT intermediate contract, and they pleaded that this is decided to be their personal residence. But then there was proof, because in a meeting, it was discussed with the contractor later on, after the contract was concluded, that now we are thinking to actually move on and start living in the house. And so some extra sort of works were ordered as quality. They wanted to have a better one. So vitally important that a residential contract for residential buildings where the employer had the intention to use it as their residence, the point of time of intention is at the time of making the contract. And also there are excluded contracts, like, for example, nuclear, uh, whatever plants or power plants. And interestingly, there are hybrids on that line, because, for example, if there are civil works and similar things within, let's say, a mechanical plant, where there are civil retaining walls and boundary walls and things like that. So for those, they're doing it. And I had, as a party representative or as a contract advisor, I constantly have mechanical electrical contractors. Even now I'm doing something for an electrical mechanical contractor in London. What happens, by the nature of the job, they at times do some civil works. Of course, they bring in specialized contractors for brickwork or block work or some concrete work and so on and so forth, but they do. And some artwork as well occasionally, because if the line is going to go underneath, underground, so they need to do so. So what about those contracts? Okay, it could be that the contract itself refers to that we will adopt the scheme and adjudication is permitted. Fair enough. So it becomes no issue anymore. That was excluded. Even if that's not the case, we're still entitled to adjudicate any dispute if that part relates to the civils of that contract. Now, if you are if you are somebody who is a contractor or advising or an employer, keep these types separate. And when you are making an application as well, make separate applications. Lord Justice Colson, towards the end of his period in the High Court, TCC, has in an excellent judgment has explained that we shouldn't exclude or try to exclude jurisdiction. So it's for the referring party to split their application and go ahead with the part which is construction applicable under the Act. Now, I've already discussed the territorial limit, and already also have covered that if, however, regardless of whatever jurisdictional issue you have, if the parties agree to live together, who cares whether there was a proper marriage or not? So that's quite common in adjudication. If you have good reason, and especially if you're a party representative, you may have a good reason not to avoid it, because it's not going to go away. You just get an extra couple of weeks' time. And so it's a good practice. The seniors or the better party representatives, I would say, simply turn around and say that, look, we can see there is an issue, and you'll go away, we will go away, we'll come back. And unless there is a personal issue with the adjudicator himself, even that can be agreed. I mean, I came across situations as a party representative in front of very senior adjudicators, very reputed one, and by their own accord, they explained that with somebody in the responding party, they have some kind of social connection. And you know what? I've raised the issue of jurisdictional challenge because my client was insisting, and I told him that, look, this is such an experienced adjudicator that it's best that you don't raise it. Eventually, the client agreed, and we've raised that flag and said that that thank you very much, Mr. Adjudicator, for letting us know that there is a connection. But as we understand, you don't need to be independent. You always needed under the adjudication law is you have to be neutral, and we'll expect that you will take an extra care. So you manifest that you are not only doing justice, it's seen that you have done it. And by the fact that you have already pointed it out, which would have been an impossibility for anyone else. And I'm repeating this statement. I will come back to it towards the end without naming anybody, to a sad saga of a very close and friend and mentor of mine, which he had in his career. And my jurisdictional challenge is something which is not only important to the referring party and the responding party. I'm repeatedly saying that it's very important for the adjudicator, and do not forget that they take a very, very serious note on the issue all the time that they're working. So normally the thresholds, we know that adjudication, all that the act of the scheme did is adding an overriding implied term into the statute, okay? And if your own contractual terms and the procedure you have set up doesn't comply with Section 108, the entire scheme, Part 1, comes into play, and then that governs it. So it's not something like you can avoid. And one of the core things, because it then becomes an implied term of the contract, so it automatically, as a matter of logic, not only it's expressly stated, it's as a matter of logic as well, the dispute has to be under the contract. So it's not relating to the contract. I will give one example only today to make you understand the point. That, for example, you are on site and you have a contract, okay? Something has been stolen, or you were negligent in not providing adequate security, which you were not under the contract required to, okay? So this is because maybe the thing that was lost or damaged is not belongs to your employer, it's to another subcontractor, and there's no privity of contract. So although it has arising due to the contract and you've gone to the site because of the contract, but it didn't arise under the contract. So the aggrieved party doesn't have a right to go to adjudication. And if that is the case, it's another subcontractor who's raising the issue that some of my things have been damaged. Fair enough. I mean, he cannot ask for this, and you should raise that. You should raise that. And I'm sure if you raise, no adjudicator will say no to it. Okay. Wrong A and B. I'm sure again that you know what an A and B I mean. It means the adjudicator nominating bodies. Okay, so to get the adjudicator, the marketplace is of course various A and Bs, and the parties modern fashion that they agree which A and B they will go to. If they haven't agreed a particular A and B, then the parties to the contract can go anywhere they want to. Okay. So, and if the construction contract doesn't have an adjudication clause, again, default position is you can go to any of the A and Bs. Now, in case the parties have said that into the contract, JCT, the contract particulars, you mention it, that which A and B would you go in case there is a dispute. Now, many a times, if you're filling up the form of a JCT new contract, I see that nothing is crossed or ticked. Please do not forget to tick one of those A and Bs. And if the A and B name is not listed, please put in writing, so that there isn't any confusion. So later on, if somebody goes, it only happened to me once in last 12 years or 13 years of my adjudication life, that parties clearly stated RICS to be the nominating body, and then went to ICE. to seek an adjudicator only once, as I said. And I remember that as soon as I pointed it out, the adjudicator, who was a senior one, he just took 15 minutes to resign. So this is something that if you can point out, then yes, you have a very valid thing. But one thing the responding parties, when they raise it, they do not consider sometimes is it really worth, or is it a good idea to ignore it because the adjudicator is somebody who's quite experienced and he's a reputed one, so let's go for it. You know, that's a consideration for the responding party, but because it's not going to go away, keep that in your mind when you are making a challenge. Wrong contract, very vital and important thing, because an adjudication decision is only valid if it has arisen under the contract. Now, if the contract under which the adjudication is brought in different from the contract which is between the parties or should have been the subject of the adjudication, then there is no valid decision. And again, the adjudicators, it's so vital a thing that adjudicators, the first thing they do, if you are familiar with adjudication decision, you will see that the first part, the very first few paragraphs after mentioning the parties, the adjudicator try to identify the contract itself. So if you have a doubt, and what are the areas where you get doubt? For example, you had a what is called an ITP, which is not a full contract, you know, an instruction to go ahead and do some job temporarily, and which says that unless a full contract is entered into, there isn't any contract, and that's not a construction contract. So this sort of things, you know, brings difficulties. Now, if the project works have completed, then there are rules of construction which allows the adjudicator to say that, okay, although the one what is relied on is not the contract they're talking about, but there is a contract. There is a contract. And as long as that is the contract under which the adjudication case is developed and presented, he still will have jurisdiction. So, but you know, these are vital issues. The wrong party, more important. Sometimes a very, very vital thing. And again, from my experience as a party representative, what actually happens sometimes, that one of the parties, I kept reminding this because I had it more than once in my lifetime. And I was fortunately on the side where we were raising it as a defense. And I have experience in arbitration where the arbitrator actually disregarded the defense. That I don't mind. A simple example, that you start as an individual, or let's say ABC Company Limited, and then there is a reconstruction or an assignment to you A to B, or to ABC Limited to ABCD Limited. And that the effect of it is under the company law, which changes the identity, or an assignment without taking a prior consent, which was a contractual precondition that before the contractor transfers, so the employer transfers their rights and interests, there has to be a tripartite agreement or anything like that. And that didn't happen. Or a novation was required, but the novation never happened. And the new party never demanded performance from the other side. Your adjudication's bound to fail. There's no one who can save it. So don't take a chance that, okay, this is more or less the same. No, this is not more or less the same. Clarify it, see who's the right, if the right party is bringing it. If the identity has been changed, it's not the end of the world either. Okay, it's very, very easy. not to go into the complex arguments of novation, blah, blah, blah. Simple. Withdraw the adjudication and then restart it as A, acting as an agent for B. So for instance, I, Mohammed Haque, started a construction job as Mohammed Haque, supplying my contractual services to a construction project. And then I have registered a company, MAH Resolutions Limited. As far as that contract is concerned, doesn't matter if the employer pays me into my new company account and the VAT number has been used, it's not going to change anything. If I want to bring an adjudication, only I as an individual can bring under the original contract with the employer. And if the reality is that I made an invoice under MAH Resolutions Limited, it's not the end of the world either. And I do not need to get into the complex discussions of novation and all these. Simply, I can say that I was the contracting party and I've registered a company limited, MAH Resolutions, and I have appointed MAH Resolutions to act as an agent to make the invoices. End of. If you have any doubt whatsoever, I was involved in a situation like this as a party representative. I've successfully done up to the High Court 2 cases, Rob Parson trading as Kilcar Projects Limited. In front of both the cases, the adjudicator was Matt Molloy, and I don't remember whether the first one was Stuart Edward or Stuart Smith J, as they then was, but arguments from a leading chamber that this is nonsense, this is an attempt to avoid or bypass the jurisdictional issue was simply rejected by the TCC, as well as, of course, by the adjudicator as well. And this has been tested twice, although Rob Parson v. Kilcar Project was won by Rob Parson, Kilcar Project v. Rob Parson. Kilcar Project won the issue. It was a minor issue that was not important, but that was fundamental, which has set the ball in rolling for Grove and all other decisions. So that has been tested and it's quite popular to be used. So don't get confused that, oh my God, there was no novation, what's going to happen? I didn't take a prior consent before assignment. If they raise this issue, what's going to happen? Nothing's going to happen. Just take an authorization from the original party, because at common law, the original party has all the liability and the benefit rights there. So he can authorize the second party as just as an agent, or acting on behalf of him, or bringing this suit on behalf of him. That's it. Okay. The scheme doesn't allow you to bring an adjudication. Listen to me carefully. To bring an adjudication which is same and substantially the same dispute of another adjudication, not a case law, not a litigation or anything, and was decided. The last point is very important. I have, as a referring party, seen hundreds of times that people didn't understand. Okay, when I was going through the recruitment process of RICS, this was a question, and very rarely the ones who were trying to get through could answer it correctly. That just because there was another adjudication, it doesn't mean that an adjudication cannot be started. The second adjudication cannot proceed if the first adjudicator has decided a dispute which was same and substantially the same. So and this is another, regarding Grove, another misunderstanding which I wanted to clarify today, that, for example, there is a decision on payment adjudication. Okay. Now, you cannot start a valuation adjudication till you pay the sum of the payment adjudication. That's absolutely clear. But if there is an adjudication going on a payment adjudication, no one can stop you to start a valuation adjudication. You understand? Now, if only the payment adjudicator decides the payment adjudication before the valuation adjudication, then the responsibility comes that you pay first and then continue. More importantly, remember that in a payment adjudication, if you have your valuation argument ready, you as a responding party simply can tender it as a defense. An adjudicator doesn't have any chance to avoid it. It's clear law that he has to consider the defense. So although you cannot re-adjudicate the same application, for example, or the same sum, unless you paid the payment adjudication first, there's no bar for you to take the valuation as a defense within the payment adjudication. No law has ever said you, and no adjudicator will ever stop you submitting your defense, because it could be resulting into a set-off simply, So it's highly unlikely. I mean, there are technically theoretical possibilities, but no, if you can tender it as a defense, that will go ahead and the adjudicator will consider it. More importantly, you receive a payment adjudication, you start on the next day a valuation adjudication. God knows, you might have your decisions earlier. Or even if not, so by the time you are paying, you are there. Your valuation adjudication is decided. So that's something, please keep in your mind. I'm hammering the point back that the scheme didn't tell you not to start two adjudications. It said you cannot take or decide the same and substantially the same dispute if another adjudicator has already decided it. Started deciding, no, not started deciding it. If another adjudicator has already decided it, only then the issue of jurisdiction arises, okay? Interestingly, just in last week, I am sitting on 4 adjudicators between the same parties, one after the other, and I have received an email from the responding party that, Mr. Adjudicator, we have moved the TCC with the mistake you have done in rejecting our jurisdictional claim. And so the TCC kindly said that you can't proceed till the decision is finally finalized, okay? And TCC is very, very quick on these sort of things. So they made the application on 23rd, and TCC said, well, we'll hear it on, say, 23rd was probably a Wednesday or Thursday, or we'll hear it on Monday morning. So the point of issue was that the parties have earlier had a litigation, okay? Normally we get situations like 2 adjudications, but these parties earlier had a litigation. And unfortunately for the responding party, the litigation was not reached the point of trial. The claim was struck out, and the order didn't say that is finally determined, because there is a limit in section 108, which says that an adjudication decision is temporarily binding only up to the point when it's finally determined by a court of law or an arbitrator. Now, obviously striking out is not a final determination anyway, and neither did the order say so. But the responding party says, look, the claimant there asked for a permission to revive the litigation. If you are a civil lawyer, you will know what I'm talking about. But the court rejected that permission. And they said that has reached finality and they can't come under a different forum. Okay. Now, mind you, there isn't any decision. But if only thing stated into the act is, I cannot sit on an adjudication if that has been finally determined. A normal course of anticipation of the statute was that an adjudicator will decide first and then finally determined, but it happened just other way around, that it was litigated but not finally determined. So from the act, I've decided, and again, I have about 8 years ago, I was listening to a face-to-face seminar by one of the leading adjudicators in the country, and he raised it, and he discussed the logic that this is what the act is thinking, this is where the act is not saying anything, but this is what the adjudicator should apply in his mind. That's how should apply his mind, that look, there isn't a final decision, so I don't care. So volumes of counsel, solicitor firms, blah, blah, made like 90 odd pages of arguments that this reached finality. And I've given 4 sentences back to them after receiving everything. That's natural justice. That, thank you very much. The scheme in the act says like this. I haven't seen any evidence that this was finally determined, neither in the order itself, nor in any case law, that for the purpose of the adjudication, this has been finally determined. So thank you very much. I'm not interested, I'm proceeding. So that was, there were by then already 3 adjudications are submitted before me. I've now received the 4th one as well, and anticipating a couple of more. Now, they went to the TCC, and because I've mentioned this, because I remember that webinar, sorry, that was a face-to-face seminar, and the adjudicators, leading adjudicators' view, and all I had to do is just recapture that in one paragraph and send it back and say that there isn't actually a clear decision of the court. So probably because of that observation within the view, non-binding, the TCC chair sat on it, and she only took half an hour and an hour to dismiss the application. So that's the point I'm sometimes trying to make, that look, just because if you're confused, just don't go there. And remember that same or substantially the same dispute must have been decided earlier. So if there was another adjudication in which there was a jurisdictional challenge, it was lost, or the adjudicator didn't provide the final decision, doesn't really matter. Don't bring that in, it's not going to happen. Okay, now dispute did not crystallize. An almost impossibility. Lord Justice Colson last year extrajudicially said somewhere that when did you guys have found a case where the dispute didn't crystallize? And then he said, from memory, I can't think of one. And it possibly rarely happens. So normally, you would by the time you come to the adjudication, you will have back and forth so many correspondence that there is a dispute. And sometimes, as it happened, as I was saying, that I'm doing something for an electrical mechanical contractor, where of course the adjudication, the contracts expressly allowed adjudication because there are civil works involved in it as well. And the other side, a very international corporate, I've sent my final version of the claim 7th of June. They're saying we are considering it. And then they said, we are going to our lawyer team, we are going to our quantum team. Up till now, no answer. And I had a conversation, a Zoom meeting with my client yesterday that we'll wait another week and we'll go ahead, because millions of pounds we are entitled to. So why shall we wait for nothing for ages? So that's how, even if, there are people who said, send the claim today and go tomorrow. No, that's not going to happen. They shouldn't do it. But allow a reasonable time, and most of the time it will be decided that this is the adjudication dispute has crystallized. Previous adjudication, I've discussed it, that only decided, but the same dispute, fine. And we now know that from Harding v. Pace and Grove's case that it doesn't matter if the previous adjudication was payment adjudication and the new one is about valuation. Arising under the contract, I've already discussed it. Is the dispute too complex? Well, I mean, I've never seen, there are case laws, one or two, that this is something is so complex that an adjudicator would say, I won't be able to handle, or the parties would say that this is not appropriate. So another thing which is a theoretical possibility, but not anything else. Now, the last point I wanted to touch on today, and of course, under the earlier slide, I've discussed the arbitration and litigation point anyway. So was there a breach of natural justice? Again, what is the breach of natural justice? What is natural to justice? Because it's not justice of the nature. It is natural justice that is natural to the judicial process. I say to you at the beginning that Adjudicator's office is a quasi-judicial body because it's deciding the interest and the rights of the parties. So they, under the administrative law of the country, has a overriding common law obligation of to remain neutral and act impartially and give the parties adequate hearing and not to commit any procedural irregularity. All of these are part of common law natural justice, but having said that, the scheme also refers to the same concepts. So for instance, scheme makes it categorically clear where the scheme applies that the referral must be given, the word is used given, within 7 days the date of the notice of intention to adjudicate. If it comes on the 8th day, no one even by agreement save it unless there's a clear agreement which says that from now on, this adjudication will proceed under this ad hoc contract to proceed, or agreement to proceed, in which the scheme is to be applied other than this provision. You can't save it. So there are, if the adjudicator fails to issue the decision within 28 days as calculated under the Act, within 19.1 A and B and all these, unless they can do so, and if the aggrieved party issues another notice, it's gone. This adjudication is no more valid. So these kind of procedural irregularity, that's what I was telling you, that even after the adjudication, if it's on the 29th day, okay, I mean, my wife happens to be a counsel as well, and she asked me a couple of years ago that a friend of her received a brief that the adjudicator decided on 30th day, and she was asking me, is it possible that he can? I said, no, ask your friend just to simply say goodbye. They cannot save it. So these are procedural irregularities, mandatory requirements, and of course is a breach of, creeping through this indirect route is a breach of natural justice, okay? And as I said, yes, it can be rectified, provided when it was found out, the parties agreed to. And for example, there was a decision on the 29th day, and then the party, he asked, who's the aggrieved party, he asked the adjudicator to correct it under the slip rule. Lost. The procedural irregularity concept is lost. Okay, but the 7-day rule in the first thing, not lost. So vitally important all the parties. And you can imagine, after working hard for 28 days, if we come to a situation where I won't get my money for a technical error like this, how serious the adjudicator is to ensure. So it's not only the headache of the responding party or the referring party, it's the adjudicators, equally the adjudicator's headache. Failure to act impartially. Why I'm using this, the bias and this is a concept, it runs through the thread everywhere, like in the court and everywhere. But there is a difference in adjudication because it doesn't require you to be independent all the time. It's not simply possible because I'm in the construction industry for the last 25 years. So I know so many. I've been involved with so many that if you start counting the involvements, oh, I've seen Mohammed Haque 3 years ago in a seminar of CIR. He was delivering something, and this contractor who was bringing the adjudication, he was present there. Involvement. I saw him having a drink after the session 3 years ago. Involvement. Maybe in a court of law, it's a grave offense. But in the construction industry, if you go like that, you won't get a qualified adjudicator to act for the parties. So the rule in adjudication is you don't need to be independent, but you got to be impartial. Okay, and the scheme provides that if you're an employee, if you receive money from as a consultant, you're better to avoid. Okay, if you're only connected to the party representative, not to the party itself, you may have a better chance. All these comes into show, but again, it's its own peculiar dimension. And what the adjudicators are asked right at the beginning by the A and B, that do you have a conflict? Sometimes what happens, I'm accepting the nomination, invitation and the nomination without knowing who the representative for the, what you call this, responding party. It only happened to me 3-4 weeks ago. That, would you believe, the responding party decided to appoint my colleague, our senior partner, Richard Silver, to be their representative. What can I do? But to respect, but to let them know that, I'm sorry, guys, I didn't know that. I didn't know that the responding party is going to appoint Richard. Now that it has come to know. So it's not only at the beginning, it might happen later as well. And I cannot then say that, no, nowadays this is called COVID, so I'm working from home, I will not be talking to Richard. No matter what I say, it's not going to work. So it's that much an issue for me as well. And it might happen that only in another adjudication month, in month of May, I believe, I have come to know after 3 weeks of the proceedings that an old friend of mine joined that representative firm, and bloody hell, he picked up the phone and he said, Mo, you know what? You are doing excellent. I said, how do you know this? That I'm on this adjudication? Yeah, I've joined this referring party consultancy. I had to go back to the parties and say this. That this is what the scenario is, and you have got all the freedom to go away even now. Anyway, they didn't, and I provided the a decision, and now I've been paid and all is gone. So if you want to expand the jurisdiction because you are permitted to, or even not permitted to, you are contractually want to, please go ahead and do it. Do not ruin the adjudication after the whole process, okay? And if you want to raise the challenge, raise it to the adjudicator. That's number one. He doesn't have a power to decide his jurisdiction, but he's been asked always to decide it so that if it goes right, his decision is enforced. So you might either go to the court or an arbitration on another adjudicator, okay, to take a binding decision on that. And if you want to go to the court or the arbitration or adjudication after the adjudication is over, don't forget to reserve your right that I have challenged and you refused. I'm participating. That doesn't mean that you don't have to participate. You can simply participate till the end, but properly reserving the right that this is my right without prejudice to my right to go and challenge it later on after the decision is produced. Okay. And how does the adjudicator do? If any one of you are an adjudicator, don't forget, although you are not subject to the rules of natural justice and do not have to take representation on your decision on a jurisdictional issue, it's a fundamental important point that you seek opinion from the other side. And then based on the both parties' representation, make a decision and use an impartial mind, okay? And doesn't matter that you do not have the right legally to decide or power to decide the jurisdictional issue. It's not an issue matter at all. If you are correct, yours will be always enforced. Okay? Do not make the jurisdictional issue cost a big one. Do not spend a lot of time, more than 2 hours. That's the thumb rule into the industry. If you think you are seeking more time, go and also tell that when you are deciding that because the sheer volume of these issue, I have to spend extra time. Okay, that's another very good practice. And I believe that's all from me today.
Okay, thank you very much. We don't appear to have any questions, so it looks like you've covered that perfectly. Thank you very much, Mohammed. As always, we are back with Mohammed at the end of the month, actually, with conflict avoidance in practice, where we're talking to Mohammed guests and guests including some company adopters. Next week, we have 2 on Wednesday, which is the QS series covering project security with Conor Ahern. And then in the evening, we have Richard Silver with Construction Essentials, and he's talking about adjudication. And that's at 6 p.m. So if you'd like a place on either of those, please do not hesitate to email me on seminars@silverllp.com. We'll happily book you in. And as before, if you have something specific you'd like to ask Mohammed but didn't want to an open forum, it is Mohammed Haque at silverllp.com, and he will happily answer those questions for you. Okay, thank you very much, Mohammed. That was a really interesting talk there. Thank you to everyone for attending, and we hope to see you all again very soon. Take care, everybody.
Thanks, Julie.